Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Put your questions in the comments now so that I can answer your questions. Now, I'm going to start while you're putting your questions in. I'm going to just start with a little introduction here. So, I do have one topic I want to get through, and that's, do you need to leave to get the green card? Hi there. So, um, in many cases, there are individuals, you may have seen another immigration attorney, and unfortunately, sometimes what attorneys will do is they will ask you a few quick questions, and if you, for example, are you married to a U.S. citizen? If your answer is no, then and you've already overstayed, then they usually say, well, you need to go home and wait there to get your green card. Or if you have a parent, if you're 21 or older and you have a parent here, you're trying to figure out if that citizen or resident parent can sponsor you. If you've already spoken to an attorney before, you will learn that, or you probably have been advised that you won't be able to stay here and get the green card. You may have to go through uh, an I-601, a waiver process, and that's the end of it, right? They tell you you have to go through that, and um, and that's that. However, if you want to figure out and get a second opinion, call me because first thing I do is I don't advise. Yes, in some cases, that is the only option. However, before I even advise that last resort option, I've tried to determine whether there are any options that would allow you to stay here and get the green card, or not even just a green card, to get status here, because there are alternatives just depending on what you've been through, what's going on in your life. We can look at all possible alternatives to just going home and waiting there. Because if one thing you'll notice is that if you leave the country after overstaying and you leave for more than, hey there, Alton, you leave for more than um, you leave the US after staying more than 180 days, you're going to be barred from coming back. And that's usually the case with people who have overstayed and they're trying to figure out now if they're not married, if they can have a parent petition for them or a sibling petition for them. First of all, those processes of the sibling petitioning for you, and if you're 21 or older, the parent petitioning for you can be extremely, almost impossibly long. So that's the first hurdle that you'd have to overcome. But even after waiting for that long period of time, they're not going to allow you to stay here and get the green card. You have to seek forgiveness first for the overstay, and if you're approved, you have to have and to be approved for this special waiver, you have to have a citizen or resident, spouse or parent. And then if you are approved for this, you still have to go back to the embassy. But what the waiver does is it forgives the overstay. So when you go to the embassy to go to the interview, they will not use that against you. So that's what I do in the consultations is I determine whether there are other options. I go through a list of questions that does lead to a more detailed consultation about your options. So if you want to stay here and you want to get status, you want to get the work permit, the first thing you need to do is check me, because I want to put you through that evaluation to see if we can find some alternatives here. All right, so I've said my quick piece here and I want to jump straight into your questions. So go ahead, put those questions in the comments. Now, what's the cost of the consultation? It's $150 for up to half an hour. And keep in mind, it is an evaluation because I want to find alternatives for you. We also advise you of your options or how to move forward in certain immigration situations. Um, can you still travel on your T visa green card to home country after filing if you go back? Um, if you go back, we'll have hardship. So it's in a case like this right now, based on policies and practices, I would say it's on a case by case basis. So my answer wouldn't be no, absolutely not. But we'd have to determine first what are the risk factors in your case, what are the extreme hardships that you presented when you're getting the T visa. Um, Should I file for my fiance or should I do the fiance visa? So you have to get married to do the to file for your spouse anyway. So this question looks like should I file for the fiance visa or should I file for the fiance visa? Because you're saying should I file for my fiance or should I do the fiance visa? They're both the same thing. What I often hear though is, should I file for get married and file for my spouse, or should I go ahead and do the waiver? So, in that case, let me know if you can hear me. In that case, you will need it depends on your circumstances. Hi there, just let me know if you can hear me on Instagram. So I was interrupted there, and I just want to know if you can hear me. Um, so in this case, if you are going to get married, of course, you both have to be ready for the marriage. And if your spouse is outside of the United States, you have to go through the consular process. Consular process can take right now um, years, 2 to 3 years, even if you're married. Fiance visa might be a little shorter, so it might almost get to 2 years, but you're looking at maybe more of a year and a half. With a fiance visa, it allows your fiance to come here to the United States. Thanks so much, Miss Pretty. Come to the United States to they get a visa, then you get married within 90 days and then file adjustment of status. So I say it comes down to personal preference here when you're choosing between marrying and filing or doing the fiance. You have to be a citizen, by the way, a US citizen to file a fiance visa. You don't have to be a US citizen. You just have to be either a permanent resident or a citizen to file for your spouse. Spouse might be taking long if they're outside of the United States. Fiance is also shorter. However, you know, with the fiance visa, you still have to come here, get married, and then go through the adjustment of status process again when you're here. But it might be nice because when your fiance comes here, you can get started on life anyway, and then go through the adjustment of status. So I say it's really down to personal preference here. Fiance visa might be faster. Is it normal to get scheduled for an interview in 2024? I submitted all my bona fides. So sometimes they have additional questions. Just you need to be ready for that interview. It could be anything that they need to ask. They are waiving interviews nowadays, especially if the application is very complete. So usually they are reserving interviews where they have questions or they notice something in the file that they want to look at, or they want to really make sure that you are a bona fide couple. Can I travel to another state in Mexico with advanced parole if it wasn't in my application? So, another state in Mexico. I wouldn't be able to tell you. So, if you're going to another state in Mexico, then if it's not, no, if it wasn't in your application, um, you know, I would have to figure out what kind of application you had and what your limitations are here. So, I wouldn't be able to advise you. Of course, I'm not your attorney. I don't know your case. So it would be hard for me to say if say you have DACA. and you have to be very specific about your international travel, then you definitely need to consult with an attorney here to make sure that whatever you do, it's in compliance with your application. You need a consultation, go click on the link in the profile or call by going to the website. Click on the link in the profile. It's like a one-stop shop. You'll see everything you need to get in touch with us. Can my permanent resident husband file for me while I'm out of status? You will not be allowed to stay here and get the green card unless, it sounds like your spouse wants the petition for you, a file for you. So it doesn't sound like that's the problem here. But if your spouse was mistreating you and you qualified for VAWA, then that is an exception and that allows you to stay here. But you do have to go through a two-step process. First, you have to apply for VAWA and then wait for your immigrant visa number to become your priority date to become current. The wait list is right now they're processing September 1st, 2023. So it could be anywhere from 6 months to a year until we see some movement. It's been like almost 6 months or 6 months, and we have not seen any movement from them processing any processing applications on or before September 1st, 2023. So that should tell you that even though it looks like they're processing a date that's fairly recent, it can still take a long time. I filed my asylum, later changed status to marriage. Can I travel out of the US with limited visa? You now keep in mind that's not stopping immigration from still saying, hey, you filed asylum, you said you're afraid to go back, but you said that under penalty of perjury when you signed the applications. And so they can find you for fraud anyway if you go back and they feel like you just submitted a frivolous asylum application. So once you file that asylum application, guys, it's on record. There doesn't Nothing is stopping them from going back and looking at and corroborating what you said compared to your marriage-based application. So that's just another reason that if you should not take asylum lightly. It is not an option. In a way, it is like a last resort option, right? Because it's not something that is going to you can file for, get the work permit, and then continue to go back to your country if you apply for something else, right? They're going to hold you to it. Would you recommend someone apply for asylum in Florida, Fort Lauderdale, not a border crosser? It doesn't matter where you are in the US. If you qualify for asylum, you can apply. What happens if I-360 is denied and I'm doing adjustment of status? So if the adjustment of status is linked to the I-360, the adjustment of status is going to be denied as well. I'm currently, um, go ahead, give us a call. We will be happy to discuss anything with you. And good or bad when you change your case to a different location. So if USCIS is changing it to a different location, right now they're doing that to try to balance out and distribute the workload. Can my wife file for my son? If you and your wife were married before your son turned 18, so if your son is currently under 18, then and your wife is either a permanent resident or a citizen, yes. And my daughter father a visa to come here with her birth certificate? No, so she has to get a visa. Good afternoon. What happened to my spouse? Okay, would your spouse know about the T visa? No, it is confident. Now, keep in mind, would your spouse know about the T visa? It depends on how you approach this, right? Some clients require a lot of confidentiality and protection. And so in cases like that, it's hard for the spouse to know that you're applying for the T visa. And no matter what, the T visa is confidential. But there is a process to get to the T visa. When I work with my clients, confidentiality is very important, and because of that, my clients do get through the process without the trafficker being able to implicate them in the process. My husband and I only have selfies together. Is that going to be a problem? Um, not necessarily. I mean, I usually say this though. Pictures, it's nice to have pictures. It's usually like when we go to interviews, when I go to interviews with my clients, the pictures is by the time the officer is looking at the pictures, they've already made their decision. They just tend to scroll through the pictures to, as an icing on the cake. But it's not going to be the deciding factor here. Make sure that your other evidence is good here. If you're going to choose pictures, make sure you choose pictures with other people, not just selfies, but other people, other backgrounds, seasons to show the passing of time that you've spent together over holidays and seasons, and just to show that you are always together. But the pictures are nice, but it's not going to be what makes your case. All right. Thanks for your continuous support to the immigrant community on an affidavit. If 1 year is below poverty line, can a statement explain the reason since other 4 years are 4 times the amount? So, the most important tax return here to show income is going to be the most recent year. So, if the most recent year, then you should be fine. If it's the most recent year that where you're below the poverty line, then you're going to want to make sure that you can provide more definitive evidence that you're on track to make the amount that meets the income requirement. Is it a possibility that you don't need the I-601A waiver even if you overstayed adult child of USC, especially if I applied for before I was out of status? It's really getting frustrating. I understand that based on just the limited facts here, if I would conclude just based on these limited facts that you've given me, you do qualify. You would have to go for the I-601A waiver. There usually is no other way to get around that I-601A waiver unless you qualify for an alternative VAWA. If your parent mistreated you and you're under the age of 24, VAWA may still be a viable option for you. Also, the T visa, U visa if you've been victim of a crime, T if you've been mistreated, overworked, underpaid by an employer. That's a good starting point to determine whether you qualify for the T visa. If you've overstayed more than a year, or you've been here more than a year since your entry, asylum is looking less like promising alternative, but it still may be depending on your circumstances. So this is just goes to show you need to get a professional to give you an evaluation here, and this is what I focus on. How long does it take to get U visa after getting bona fide determination letter? Does getting a bona fide letter mean I have been pre-approved? I would say it's like a pre-approval, right? But like pre-approved, for example, you're going for a house, right? And you get a pre-approval letter to start going and shopping around for the house. That pre-approval can change. Say when now they're going through the underwriting process where they're determining your loan amount and confirming everything. Say they find something new and they're like, you know what, we can't fund this mortgage for you anymore. It's the same thing, right? Where you get sort of a pre-approval through the bona fide determination letter, but at the same time, that can always change when they start to do a more detailed review of your case. So stay vigilant. After filing an I-360 petition, VAWA, how long can I file for my adjustment of status to get work permit? My I-485 was denied. So you're going to have to wait for your priority date to become current, and that's depending on the visa center. Hope you have yourself a productive day. Thank you so much. I do need that, so thank you. All right, I'm going to go through these questions very quickly on Instagram, and then I have to head out. Hi there, Nuzzy. It's nice to see you. Thanks so much. I want to know about DACA dreamers when DACA is gonna be ruled. So it's going through the courts. Unfortunately, there's no end in sight right now. After my interview on Friday at the U.S. Embassy, the consular officer took my passport, awaiting medical, didn't give me any form or paper. I checked my NBC portal, seeing petitioner. Okay, so sounds like the embassy is waiting for some documents. It can take a while depending on when they get the medical, how long it takes for you to submit any additional information they need. So it could take a week, take 4 weeks, just depending how fast everything gets. My dad submitted the I-130. He's a citizen. How long does it take for it to be approved? Because when he checked the portal at progress, it says 2 months. So if you're 21 or over, even if it gets approved, you're not gonna be able to get anything with that. It's gonna go to the embassy in your home country and it's gonna sit there for another 5 to 7 years, and then you have to wait for your priority date to become current, which would be 5 to 7 years. Then at that point, if you're all still in the US, you would have overstayed, of course, over a year. So that means that if you set foot outside of the country to go to the embassy for your interview, you're going to be barred. So you're going to be denied at the embassy. That's also a trap that some people fall for, unfortunately, if they're ignorant about the bar, the 3 year or the 10-year bar. So here, if you're not under 21, you have to find an alternative here, and you can always schedule an appointment and we can talk about some alternatives. I'm on H-2B program. Can I apply for a green card? No. So just having an H-2B alone isn't going to qualify you. But if you do other things that qualify you, like say you get married to a U.S. citizen while you're here, that can qualify you. Does being filing for affect the renewal of one's visitor's visa? So I've seen people who are 21 or older continuously get their visitor's visa, and they usually continue to allow them to travel as long as they can show that they continue to maintain strong ties to the country. All right. If my passport is expired, can I start my green card through marriage application without renewing it? So we've gone ahead and we've submitted it, but we've made sure our clients renew it while we're waiting for the process to go forward. We don't want them to wait weeks and weeks and weeks and weeks to get their passport. Time is going, and we just want to make sure they get their process going. So we tell them renew their passport while the process is pending. And if they get an RFE, I've not never gotten an RFE, but if you get an RFE for the passport, then you can submit it in. All right. All right. Okay. My husband wants to start green card system. My passport is expired, so I just answered that. Can I file for my step son without the mother's signature? Yes, but when it comes to the stepson coming to the US, you might need her cooperation at that point. If my mom is a resident and my sister, who is 17, had a non-immigrant visa and is currently in the US with us, can my mom file an I-130 for her and we can file an I-45 for her to adjust status? It's not that simple. No. So it's not gonna be that simple. She cannot overstay. Right now, the priority date isn't current, so my answer would be don't do it. You're gonna regret it. Get legal advice first. Please make sure you do that because I've seen this mistake happen, and it becomes really devastating to that young person, that 17-year-old. is going to face a lot of bad consequences as a result of it. So get legal advice first. Don't jump and file any papers because it's not going to end well. What happens after your biometric appointment when you are doing AOS? Uh, then you get your work permit next, hopefully. All right, that's gonna be it for me today. Thanks so much, everyone, for your time. I'll be back tomorrow and we can talk some more. So if I didn't get to your question, please save it and come back and put your questions in the comments and we'll talk about it then. Thanks so much. Have a good day. Bye.